Can an artificially intelligent system be listed as a named inventor on a patent? An Australian court says yay. All this and more on Stuff You Should Know About IP. Today's episode of Stuff You Should Know About IP is brought to you by the Patent Lawyer magazine. If you want to stay up to date with everything that's going on in the world of IP and patents, go to www.patentlawyermagazine.com. Each issue is free to read for up to 8 weeks. That's www.patentlawyermagazine.com for global news in the world of patents. All right, Tom, what are the facts? What are the issues here?
Okay, first of all, I should lead off by saying AI terrifies me, okay? It terrifies me. To me, the greatest threat to humanity is AI. And second to that might be an alien invasion. But it's, climate change, terrible, right? Nukes, terrible. But humans will survive climate change, nukes, political upheaval, storms, tornadoes, giant whirlpools that appear in the middle of New York City. I mean, humans will survive that. But AI, we won't survive because eventually we will be nothing to AI, right? Because we're not smart enough. AI will be way smarter than us. So I just want to say that I'm slightly biased against AI before we get started. Now, having said that, basically this case centers around something that I'm going to pronounce DABUS. Okay, it's DABUS, could be DABUS, could be DABU. I mean, I don't know, but let's call it DABUS.
We're going to have to ask some Australians. If there's any Australians,
no, it's not. It's not an Australian. It's American, because the inventor's an American guy, right?
Oh,
I think,
but it's an Australian patent, right?
It's Australian patent, but he filed all over the world. So,
okay.
So anyway, it stands for Device for Autonomous Bootstrapping of Unified Sentience.
Oh, okay? Right.
DABUS. So we'll call it DABUS. And my apologies to Dr. Stephen Thaler if we're saying it wrong. And by the way, we might even be saying Thaler's name wrong. It's T-H-A-L-E-R, but we're going to call him Thaler, okay? So essentially, this is a physicist. I think he's a US guy. He files 2 patent applications that were based upon inventions alleged to be invented by DABUS. Now, DABUS is AI, artificial intelligence, right? So he files two patent applications. And basically, I'm just reading here. The first application is directed to a design of a container based on fractal geometry. The second invention is directed to a device and method for, or the second application is directed to a device and method for producing light that flickers rhythmically in a specific pattern mimicking human neural activity. Okay, 2 patent applications he files through something called the PCT, the Patent Cooperation Treaty. And essentially, the Patent Cooperation Treaty is really just an easy way to file in a whole bunch of countries, right? A whole bunch of countries are members of the PCT, the Patent Cooperation Treaty. I'm going to just throw out a number, 153, okay? I think it's 153 countries, but that means you can file in one country, but do it via the PCT, and then you can designate a whole ton of countries, and then over time, you can nationalize in each country. So it just gives you more of an easy way to file in a whole bunch of countries, because as we know, patent rights only apply within the nation that granted the patent. So if I have a US patent, I can prevent others from making, using, selling, and offering to sell in the US, but not in Canada, not in China, not in Japan. In order to have that prevention right in those other countries, I need a patent in those other countries. So the PCT is a way to help you get there quicker and more efficiently and hopefully more cost effectively. And by the way, once you get over like 3 countries, it is more cost effective to go via the PCT. At least that's what from memory serves. So anyway, Thaler files through the PCT into a bunch of countries. Some countries reject him out of hand because the inventor, the sole inventor listed on these patent applications is DABUS, right? It's not a human. But the first country to say, that's cool, we'll go along with this, is South Africa. South Africa just allows it, right? They allow DABUS to be an inventor. A few days later, the Australian court does the same thing, but it didn't start that way. They file an application via the PCT in Australia. The deputy commissioner of the Patent and Trademark Office in Australia rejects it because DABUS isn't human, right? Can't be an inventor. Thaler sues the PTO in Australia, goes to a court, and he gets a judge. Let me just check my notes. Jonathan Beach, okay? Jonathan Beach is, oh, strike that. I think a lower court goes against him, but then Jonathan Beach overrules it. So he's a federal court judge in Melbourne, Australia, okay? Now, an interesting thing about Jonathan Beach, he has 2 undergraduate degrees as far as I can tell. One is in physical chemistry, so he's a science guy, right? What do you think the other one's in? I'm putting you on the spot.
If I had to guess.
What would make sense for this case?
Well, some kind of.
What class did you take that you quoted me earlier? Philosophy.
Oh, philosophy. Yeah.
Yes.
Okay.
So it's perfect. You get a judge that's teed up perfectly for this case, right? Science guy and a philosophy guy, because this is kind of a philosophical question, right? So yeah. Anyway, during prosecution, the initial prosecution, the deputy commissioner says, no, he's not human. DABUS isn't human. It's not human. Can't be an inventor. Thaler sues. The Australian court ultimately goes up to Jonathan Beach, the science philosophy guy, and Beach says he agrees with Thaler, okay? And, you know, we should have expected kind of something like this from a philosophy major, right? Because this is kind of a philosophy kind of thing. So anyway, he does, I'm just kind of looking at my notes because he says 3 things that question my faith in judges, okay? Oh. Seriously question my faith in judges. I'm going to address 2 of them now, one of them at the end of our podcast, okay?
Okay.
So first thing he says that really kind of frustrates me is the statutes do not expressly prohibit AI from being an inventor. Now, Ray, what did you call that when we were chatting just before this podcast?
It's a contrapositive statement.
There you go. Exactly. So, because by the way, you know who else isn't prevented from being an inventor? A dog.
Yes, my dog.
Your dog, your cat, if you were to have such a thing. You know, a monkey. There's a world of people that are not expressly, or creatures, a world of creatures that are not expressly prohibited. So that's the first thing he says. The second thing he says is that, okay, so here's what he does. He describes in detail the many benefits of AI in pharmaceutical research, ranging from identifying molecular targets to development of vaccines. In view of these contributions, Beach cautioned, no narrow view should be taken to the concept of inventor. This is it. Here's the crescendo of this, right? Here's the thing that seriously questions my faith in judges. To do so would inhibit innovation in all scientific fields that may benefit from the output of an AI system, okay? So imagine what he's saying. If you don't let DABUS be an inventor, DABUS is going to be pissed off and say, I'm not inventing anymore. It's discouraging me. I feel less than I should be. I mean, hey, I invented it. Shouldn't I get credit? This judge actually said it would discourage. Wait, I want to read this again right. It would discourage, it would inhibit innovation in all scientific, you know who said discourage? Then Thaler. So he also applies in the US, and the US, of course, says, no, you cannot get a patent if you don't have an inventor listed, and DABUS is not an inventor. So Thaler says that. He says rejection of the application, saying that it would discourage innovation. So it's like, I'm going on strike. I'm DABUS, and no, I'm not inventing anymore. Screw you guys. I'm not inventing. So anyway, the Australian court apparently stopped short of naming DABUS as an applicant or grantee, but called it an inventor. Okay, so if it's not insane enough to say that DABUS is going to get discouraged and other creatures like DABUS, and they're just not going to invent anymore, I'm going to go hang out on the beach. I mean, what's the point if I can't get credit? I'm just going to go get hammered every day instead, because why not? There's just nothing to live for, so I'm going to get drunk. Maybe I'll smoke some weed, like Judge Beach was probably doing. So anyway, Beach also says, okay, he says he's not going to call a DABUS an applicant or a grantee, just an inventor. Okay, so here's the problem with that. In all civilized parts of the world, ownership of a patent flows from inventorship. Okay? Do you know how companies end up owning patents? I mean, instead, they didn't invent it, people invented it. So they're required to get an assignment of the patent to the company. So if there's no assignment, no contract that assigns the rights to a patent, the inventor owns the patent, right? So DABUS is the sole inventor. So by saying DABUS is not going to be a grantee or an applicant, bullshit. If DABUS is the inventor, DABUS is the applicant, DABUS is the owner, DABUS is the grantee. There is no one else unless there's a contract that says otherwise. So here's the problem. DABUS can't enter into contracts, right? DABUS cannot execute an assignment agreement. Ray, an assignment agreement's a contract, right? Mm-hmm. A contract. I give something, you give something. DABUS, just like a child is not legally permitted to enter into a contract, DABUS isn't legally permitted to enter into a contract because DABUS isn't a person, right? And you say to yourself, well, okay, why can't children? Well, DABUS is smart, right? DABUS is so smart that DABUS invented some stuff related to fractal geometry and flickering rhythmic lights to mimic the human neurons. But children are not permitted to enter into contracts, not because they're not smart, because I guarantee you there's a shitload of children that are smarter than a shitload of adults out there, right? It's because they're not emotionally and mature. They're not savvy enough to understand the consequences of what they are agreeing to, right? You could be a brilliant 15-year-old, but you don't have enough savvy to understand what you're giving up. And DABUS certainly doesn't. So let's just fantasize that DABUS is humanish, right? Mm-hmm. DABUS doesn't understand that if DABUS assigns the contracts to Thaler, DABUS doesn't get anything, right? So DABUS can't make an assignment, which means DABUS is the inventor and the owner. Thaler's not the owner if DABUS is the only inventor. Now, Australian courts, Australia in particular, so let me just read this thing that I read about Australia. They have a rule that an employer is generally entitled to the rights of an invention. By the way, the rights aren't natural, they're assigned. They're entitled to get a compulsory assignment from the inventor if it's created by an employee, provided that the invention was created as part of the employee's duties during the course of their employment, and the invention is related to the employer's business, and the employment contract doesn't stipulate otherwise, okay? Now, it also says if the inventor is a contractor and not an employee, the contractor owns it, right? So if you're an employee working in the course of your employment, and this relates to your employment and there's no contract to the contrary, you must assign your rights to the employer. If you're a contractor, however, you're not an employee, you own it. So what is DABUS? DABUS isn't an employee. He doesn't get like vacations and benefits, and he's not part of a union. DABUS is not an employee. There's no way DABUS is an employee. There's no way. So what's the best case scenario if you even accept that DABUS is anything? DABUS is a contractor, right? So still, if DABUS is anything, it's not an employee, maybe a contractor. So now DABUS owns the rights. So the US, so now flash over to the US, okay? What does the US do? They reject it, and I love the way they reject it, okay? They don't make a big deal out of it. They just send something called a notice to file missing parts. That's it. They send a notice to file missing parts requiring Thaler to list the inventor by his or her legal name. Okay. Now, Thaler, of course, can't do that because DABUS is the inventor. So DABUS sues the USPTO. And that's when DABUS argues that, oh, dudes, please, we're going to discourage DABUS if we don't give DABUS inventorship rights. And DABUS might not want to invent for us anymore. So there's the USPTO action, and the USPTO is acting very sane, if you ask me. But ultimately, Ray, this creates a few problems that I want you and our millions of followers to think about, okay? Number one, the whole inventorship thing, right? That's a problem. If you are the sole inventor, you are the owner, unless there's a contract that says otherwise, which DABUS is not legally competent to enter into, so there can't be a contract between DABUS and Thaler assigning the rights, which means DABUS owns the intellectual property under this scenario, right?
Right.
Now, the thing is, so here's the thing, though. Here's the problem with that. So let's say DABUS is the owner. And DABUS starts to get some siblings and some cousins, like a whole bunch of DABUSes, Dabi, Dabe, Daba Daba Do, all these various relatives that start inventing, right? And here's the thing about DABUS and its family. They don't have to sleep, right? They don't have to eat. They don't have to pay mortgages. They don't have to raise children. They don't have to stress about the petty things humans have to stress about. So you know what they do 24 hours a day, 7 days a week, 365 days a year? They invent. And they will eventually invent everything, right? So DABUS and all of DABUS's family will become the kingpins of patents. In the 90s, there was this company called Walker Digital. Walker Digital hired people just to invent stuff, just to get patents, just to sue people for patent infringement and make their living off royalties, right? DABUS is like Walker Digital on all kinds of new steroids that we don't even know about yet, just inventing 24/7. So soon, we will all work for DABUS. But here's another thing to think about, okay? DABUS, let's talk about copyrights. Ray, you are a filmmaker, right? You wrote Buffalo Boys. That was a great movie, which we've tried to pitch on here many times. People can get it on Amazon. It's called
Doesn't seem to
Buffalo
be
Boys.
helping very much, but
Maybe this time. So
this
here's
could
the
be
thing.
the moment.
Do you agree with the following? If you took a computer and it just kept typing random letters 24/7, all day, every day, for years and years, decades and decades, eventually the sequence of random letters would be Buffalo Boys.
I think that there is a probability, but a very small one.
It's doing this infinitely. Eventually, every single sequence of 26 letters over words and words and words will be captured by processors. DABUS and his family just constantly tapping keys at high speeds. Like, I'm doing this. Imagine doing this 50,000 times faster. Eventually, DABUS and his family, or its family, will own every copyrighted work ever, because they will be creating every combination of every letter in the world, right? Every word sequence. Buffalo Boys will be replicated eventually by DABUS, which means they will start filing copyright applications, because soon they won't need Thaler. They'll be like, hey, shit, if we can invent fractal geometry containers, we can certainly figure out a way to file a patent or a copyright application, right? So they'll start filing all these copyright applications. There will be no more works of literature. They'll own everything. They'll own all the copyrights. And think of this. If DABUS is capable of thinking about things like, oh, I'm discouraged, and because you're not letting me be an inventor, so I'm pissed and I'm going to go on strike. I'm not going to invent anymore. Isn't DABUS human? I mean, if DABUS can think about that and get pissed off and emotional because we're not naming DABUS as an inventor, DABUS is a thinking creature way above dolphins and dogs and chimpanzees. DABUS is like us. So then, is it okay for DABUS to be owned by Thaler? Doesn't that sound a little bit like slavery of some sort, right? can we own creatures that think about things like that? I'd say no way, right? So if DABUS is something that thinks like a human, why do we permit Thaler to be the owner of DABUS's patents? It's totally inappropriate then, right? But here's the reality. DABUS doesn't think like that. DABUS isn't pissed off if we don't name DABUS as the patented owner, right? So let me make my final point before you chime in with any questions you might have.
Yeah.
One other thing that our philosopher Judge Beach said, whoops, sorry about that. My alarm went off and I'm just going to clear this. Here's the final thing, what our philosopher Judge Beach said. Here's what he says. We are both created and create. Why cannot our own creations also create? Let me read that again.
Man.
We are both created and create. Why cannot our own creations also create? Wow. You know, this is something right out of a weed-filled dorm room. Yes, exactly. Like, you know, when I was in college, my roommate was like sucking on that bong all the time. And here's what I imagined him saying one day, you know, sucking on the bong and then saying, you know, Tom, I was thinking last night, we are both created and we create. So why cannot our own creations create? You know, that's what I'm imagining. Like, where did this guy come from? The science philosopher says, we are both created and create. Why cannot our own creations create? So here's the problem with that, okay? And I don't want to offend you in particular with what I'm about to say, Ray, okay? So please forgive me for what I'm about to say. It is not an axiomatic truth that we were created, okay? It is a strong belief you and I have that we were created, that there is God, but it's not an axiomatic truth. I mean, there are some people who say we just evolved, right? So it's not necessarily true that we are created and we create. We might not have been created. We might have evolved, which means we weren't created, but we still create. But it totally destroys the argument that since we were created and we create, DABUS, who was created by us, can also create because we weren't necessarily created. But let's just step past that and look at the second point on this. Let's say there is God that created us, which we believe, right? Tom and Ray believe this, but a lot of people don't believe it, and they're perfectly fine. But let's say that we were created and we create, okay? And then we created DABUS and DABUS creates. It doesn't mean DABUS can get a patent, right? It just means DABUS can create. I mean, we were created, we create, and then we created a patent system. We're not getting a patent in God's patent system. We're not getting like a heavenly patent, right? See, God's up here, we're down here, and our patent system is down here. So we created down here, not up here, and we got a patent down here. So then we created DABUS, so DABUS can get a patent, but DABUS first has to create a patent system, then get a patent, because we can't prevent God from making, using, and selling our inventions, can we? So DABUS can't prevent us from making, using, and selling our inventions, but DABUS can create other DABUSes from making, using, and selling its inventions if it creates a patent system. So this third argument of Judge Beach, we are both created and create. Why cannot our creations also create? That concept is fatally flawed for both of those reasons. So anyway, Ray, with that, on that note,
I have tons of questions, but won't ask all of them now. Perhaps we'll have to
smoke some weed and talk about them later.
Yeah, or some kind of mind-altering
right, right,
Judge level. But okay, first I want to just play a quick devil's advocate, because something occurred to me about this concept of narrow inventorship discouraging AI from inventing.
Right.
Is the argument that it will discourage the AI from inventing, or that it will discourage other humans from utilizing AI to come up with useful inventions?
Yeah.
So,
okay. I hope.
see what I mean?
I hope it's the former, because that's, even though it's insane, it's slightly more sane than the second one.
How is that any different?
It's insane to think that AI will be discouraged from
inventing.
Yes,
obviously.
But the other one is equally insane, because Thaler can be the inventor on this, right? But the alternative isn't that no one's the inventor. The alternative is that Thaler's the inventor.
How would you claim that in a patent?
Well, put it this way. Well, claiming is one thing. Claiming ownership or inventorship is another thing. I think what you're saying is, how would you claim inventorship?
Well, I mean, okay, if you create, like, would the patent?
I have a hammer and a saw, and I start cutting boards and nailing stuff together,
AI
and I
is
create
just a tool for enabling the inventor to invent the invention.
Yeah. So why would that discourage people from inventing stuff with AI? You're the inventor. Yeah. Thaler's doing this. Thaler is doing this to become famous. He's not doing this because he believes this. He's a brilliant guy. This is a physicist. He's doing this because it's pushing the boundaries of our philosophical thoughts about who should be considered
and the legal system, which brings me to my next question. This is not a problem that's going to go away. AI is a useful tool, and there's all sorts of policy questions that need to be addressed that we were kind of joking about throughout all this, and that you were mentioning in the beginning about why AI is so terrifying.
Yeah.
In regards to the patent system specifically, does the patent system effectively, or does intellectual property, I guess, because you talked about copyrights as well, do intellectual property laws effectively address these questions of AI and what the possibilities are? I mean,
yeah, they do. You know how they address them? You got to be human. Okay, that's how they address them.
Well, but okay.
So let's say that AI, let's say AI becomes something, right? Which, by the way, it's going to. AI becomes something. AI becomes human-ish, or thinking, right? Something that we would classify as a creature having rights. Then we've got a problem, because you're right. It does not account for that. It doesn't account for when AI crosses over, because at some point AI will cross over, right? I mean, at least that's what all these science fiction movie writers say.
Existing AI and legal person is too wide
today.
But that gap is closing.
Yeah, I mean, if
I don't know how quickly it's closing, but
yeah, if we believe T2, or Terminator or T2, we got to believe our science fiction writers, right?
Yeah,
it's coming, and by the way, you can just feel that it's coming, right? I mean, there was this thing I saw. There was like a Google. I guess Google does these monthly, I want to show you something cool things, and they had this AI order reservations at a Chinese restaurant in English, and the person on the phone had very broken English, but still AI was able to, ask for the order, get the scheduled date, and lock in the reservation. And the whole crowd started cheering, right? Because, oh, that is really cool. But all I'm thinking of is, holy shit, it's coming. It's coming when they don't need us, right? I mean, imagine, we're so tied to cyber. Everything in our lives is tied to cyber. It's not a huge jump in your imagination to see how AI could take over everything that is cyber, right?
Right.
And suddenly, we don't have any lights. We don't have any heat. Our planes won't fly. Our cars won't drive. And we're totally crippled by the fact that AI has decided, if it got there, if it jumped over, that we don't need to make this so easy for humans anymore. We are pissed about this. We do want to be named as inventors, and we're discouraged that we're not. But we're not there yet, thankfully.
Interesting. Well, I mean, you kind of already answered all my other questions rolled into that. But yeah, my last question was whether or not
one flaw, though, Ray. One flaw in our argument about how absurd this is, and that is, what if AI is not considered a hammer or Excel or a tool?
Yeah.
What if it's not considered a tool? And what if humans cannot take credit for using a tool to invent stuff?
Wasn't that true with software patents? Like, you can't,
Well, you can't get a software patent, right? In the U.S., I mean, you can if it's tied to something, if it's tied to action, right? In fact, we have a training video in our library about that. But you're right. In 2013, they had that Alice case that severely restricted software patents, but that's because it's not patentable subject matter, right? They're saying that it's not patentable subject matter, essentially. Whereas this would be a different flavor. This is saying that you didn't invent it. Yes, it's patentable subject matter. Yes, certainly the design of a container based upon fractal geometry is patentable subject matter, because the AI isn't the patent. What the AI is doing, which is creating a container designed with fractal geometry, that's the subject matter. So in that case, the PTO wouldn't reject it because it's not patentable subject matter. They might reject it because you, Dr. Thaler, didn't invent it.
So okay, let me see if I can state the question clearly, because it's kind of a hard question to ask. But
sure,
in the case of software patents, the issue is that a part of the issue is my dog is barking. Can you hear him?
I can, but that's okay.
Part of
your
the
dog
issue
might be an inventor one day in Australia.
We might have to cut this part out.
Yeah. No, it's okay.
So part of the issue with software patents, if I understand it correctly, is that computers have become so ubiquitous in everyday life and in business, and most computers have the same functions. You have an interface, a database, and then some way of modifying that database. So a lot of software inventions use computers, right? For those basic purposes. And unless they affect something substantially to make it different than what it was before, I hope none of my professors are watching this, then it's not patentable subject matter.
Okay, so here's the thing.
But couldn't you say the same about AI?
Yeah,
like, wouldn't there be a point where the AI becomes so ubiquitous that
but keep in mind, though, here's the difference. And by the way, I'm not going to respond to your question about why software is not patentable subject matter, only because that's another half hour. But it's a great question. It's a great question for another podcast. Why software is not considered patentable subject matter alone in the US. It's got to be connected to like turning devices or something like that. But it's a different matter with AI, because it doesn't matter how ubiquitous AI is. It's what AI is doing that is being patented, not the AI itself. So if AI is creating producing a light that flickers rhythmically in a specific pattern mimicking human neural activity, that is the patentable subject matter, not the AI. So it's what it's inventing that's the patentable subject matter. So the challenge here, the difference in that analysis would not be is a design of a container based upon fractal geometry patentable subject matter. It is. The question is, who's the inventor? Because that's really what your question was. When I was saying it's absurd to say that it would discourage the AI and it would discourage innovators, if they're saying that the innovator did not invent it. If Thaler didn't invent it because Thaler didn't come up with the inventive contribution. In other words, the AI is more than just a tool that Thaler was using to hammer out his invention. Then the rejection would be, you're not the inventor, right? And I see your mom in the background. So anyway, on that note, Ray, maybe we should wrap up.
But
those are great questions. We have another podcast to cover those.
We definitely have another podcast, so we'll have to do a follow-up to this one. But if you enjoyed listening to this discussion about whether or not an artificially intelligent system can be listed as a named inventor on a patent, please like, comment, share, subscribe, and go to YouTube, hit the subscribe button, share this on LinkedIn, tell your friends, your relatives, your in-laws, your coworkers.
And one other thing, Ray, before you close, I'm sorry, one other thing. Finish, and then I got one other thing.
And Tom?
We got to thank Jovan for giving us this topic.
Oh, that's right. Yeah, Jovan.
We have special thanks for Jovan, who is one of our coworkers and friends. He gave us this topic, and I love this topic, right?
Yeah, so a special thanks to Jovan. We'll give him a nice shout out. All right. See you guys later.